Hello and good afternoon. Welcome to today's webinar, an overview of the O1 visa for extraordinary ability or achievements. So glad everyone can join us for our first webinar in the month of July, and excited for this presentation. Before we get there though, we have a few housekeeping items to go over. First, this webinar is being recorded and everyone in attendance will receive a link to download the recording after today's live session. You'll also receive a link to download the slide deck, as well as the SHRM and HRCI continuing education credits. All of these materials will arrive in your email inboxes tomorrow afternoon, so please keep an eye out on that message. And if for whatever reason you don't receive it, just please let us know and we'll be sure to send it your way. Additionally, we highly encourage you to ask some questions throughout the presentation today, and we'll try to get to them at the very end during our dedicated Q&A session. To do so, you should see the GoToWebinar question panel on your screen, and you can type your question in and hit that submit button, and we'll try to get to it at the very end. Please keep in mind, however, that we can only answer general questions about the O1 visa. We really cannot get into any specifics. And in those instances, please consult with your immigration attorney. And final housekeeping notes, please excuse any audio or video interruptions that may occur. Internet connections may jump in and out. We are not anticipating anything, but if you experience any audio or video technical difficulties, apologies in advance. That is why we're recording. So with that, I just want to quickly discuss Envoy for those who are unfamiliar with Envoy. For nearly 20 years, Envoy's been on a mission to fix the inefficient, confusing, and frustrating immigration process. Envoy Global combines expert legal representation with innovative technology to deliver the only platform that makes it seamless for companies to hire, mobilize, and manage a global workforce. Envoy secures work authorization in over 100 countries, has grown 37% year over year, and works with over 1,000 customers. We are particularly proud of our NPS score, which is a testament to the employee experience that we provide. And leading the presentation today is Sarah Herbeck, the managing partner at Global Immigration Associates. Sarah provides strategic immigration advice regarding movement of professionals throughout the world, and she oversees a staff of over 80 attorneys, paralegals, and support staff. She graduated with honors from Northwestern University and received her JD from the Chicago-Kent College of Law. Sarah, thank you so much for joining us this afternoon.
Thanks for having me, Eric.
Great. So Sarah, before we jump into the main presentation, I just want to provide our attendees with a brief overview of today's agenda. We broke it down into two main sections, and then as I mentioned a couple seconds ago, we'll end it with audience Q&A. And final housekeeping slide, just a legal disclaimer that I will leave up for a few more seconds. And with that, let's jump into the main presentation, starting with what you need to know about the O1 visa. And specifically, Sarah, so I like talking about the O1 visa because it's such a unique visa, because only certain people are eligible. So my question is, who exactly is eligible for sponsorship?
It's those individuals who are really the experts and, nationally, internationally known as being experts within their field. And the fields are very diverse, right? As everybody can see on the slide, it's not just scientists or artists. It also includes educators, business professionals, and athletes. It also includes, movie stars, essentially, and television personalities. So it really encompasses and is meant to acknowledge those who have really excelled in their field of endeavor and expertise, and is certainly a useful tool, I think, in a lot of circumstances, for those individuals, depending on a company's need, to bring them to the United States in a non-immigrant work authorized capacity.
Gotcha. So when we're talking about the O1 or the O visa, there we have the O1A and then the O1B. So I'm curious, what are the differences between the two?
It's who's being sponsored. So
Okay.
O1A or O1B, it's what is their area of expertise, right? So O1A would be a little more traditional from a business, science, education, athletics perspective. So the first level of individuals that I spoke about. The second one is the arts and motion picture or television industry.
Mhm.
So think of those individuals. It's a little more more business side from an O&A perspective potentially than the O1B, but at the end of the day, the classification remains the same. The underlying premise that you really do need to be at the top of your field to qualify for this particular visa is the important factor.
Gotcha, gotcha. And then as we move on to our next slide, we also have the O2 and the O3.
Mm-hmm.
So, Sarah, what are these two, and who may apply or be sponsored under these two visas?
So an individual who would qualify for an O2 visa would be those individuals who either support or assist an artist or an athlete for an event, performance, or the like, and are needed as essential
Mhm.
to provide that support for that O1. There are certain caveats to that as well. O2s that you really do need to really support the idea that they're absolutely necessary for the O1 to do his or her perform his or her tasks, whether it be the artist or the athlete. They have to be deemed essential or integral to the part of why they're being why they need the visa to enter the United States to work.
Mhm.
And also, you've got to secure that O1 before you can apply for the O2. So the
Mhm.
O2 is a dependent visa, but normally when we think of dependent visas, we think of spouses, children, and the like. We don't think
Mhm.
of essential personnel, so to speak. However, as designated on the slide as well, the O3, that's that traditional sort of dependent visa that we think of, so spouses and children of O1. And
Mhm.
similar to the O3, the O1 necessarily would need to have their visa issued first, but typically families go and apply for visas together. So it's sort of concurrently done. And in this instance, they're not family members, so they're not applying typically together in O1, O2 circumstance. So a little bit different, but the
Mhm.
same type of principle where they're dependent upon the O1 obtaining his or her visa first.
Gotcha. Great. It's a good breakdown. And Sarah, as we move along to our next slide, the O visa's validity period is, definitely really important to know. And
Mm-hmm.
as we see here on the slide, that initial stay is 3 years. But I'm curious,
Mm-hmm.
what about after that?
So there's no time restriction on O1. However, once an O1 non-immigrant receives his or her O1 status for that initial 3 years, the extension time frame is different. You're extending their status in 1 year increments. And so at the end of the day, what it comes down to is understanding that this is sort of an ongoing process to ensure that they are maintaining that extraordinary status
Mhm.
on an ongoing basis. And certainly, as that ongoing basis continues to be in the United States, I would certainly encourage those O1 recipients to reach out to their immigration attorneys or their companies who are sponsoring them to talk about longer term options if that becomes a part of the overall plan from a business
Mhm.
perspective or a professional perspective.
Gotcha. And so that's going to bring us into our next section. But actually, Sarah, before we get there, I think you and we did this webinar a year ago almost. And well, first, that's crazy that it's flown by that fast.
Mm-hmm.
But fun question for you. So I think you mentioned last time that it was like you had hoped at some point to help someone that's like a Nobel Peace Prize winner, come to the U.S. So any luck on that goal yet?
Not yet. That's sort of one of my very, very nerdy immigration goals is to help somebody who's won a Nobel Peace Prize to come to the United States. But there's still time, I hope. And certainly, I think that I still really enjoy this particular visa category. I've worked on particularly a lot of scientists, O1s, and I can tell you they don't always understand everything when it's described on a scientific level. But the individuals with whom I've had the pleasure of working have always done a really good job at breaking it down into layman's terms and really being able to take it from a scientific, but really, really show the excellent contributions they've made to their field internationally, and then once they're in the United States, nationally as well. So it's really been a privilege to work with this particular visa category.
For sure. No, it's great to hear. Great to hear. So Sarah, in this particular section, we're going to move on to, I guess, just some application practice pointers, and I'm going to hand it off to you for this. I kind of let you drive the presentation, so just let me know when to advance the slide. And we are getting some questions coming in, so at this point, I just want to remind our audience that if you have questions for Sarah, just type them in, and we'll try to get to them at the very end.
Sure thing. So the O1 is very much like a typical, say, H-1B would be filed. So the first and foremost step would be obviously preparing the petition with counsel. I can tell you that the O1, while from a process perspective, where you file, when you can file, is premium processing available, is very standard. I think that one thing of note in this, and as you will see in the future slides, that there's a lot of documentation. I think this was probably one of the most work-intensive visa categories we have from a non-immigrant perspective, and rightfully so. There is a high bar to set when it comes to demonstrating an individual's extraordinary ability. There are so many ways of looking at the different factors that must be demonstrated with the filing. So while it's very simply laid out in this particular slide, there's a lot of back end or behind the scenes work that goes on to get to the point where the company, the sponsoring employer, is actually filing the petition with the U.S. Citizenship and Immigration Services, because USCIS must adjudicate and approve the petition before an individual can start working at a U.S. company in O1 status. The petition, like all non-immigrant petitions, H's, L's, and the like, can be filed 6 months out. So if you have identified an individual of extraordinary ability who you would like to start working, but they're not set to start for several months down the line, that's okay. You can actually file a petition 6 months out from the actual start date. But as always, the sooner you're aware, the better off you are to get things filed, because adjudication timeframes can vary, and we have seen some delays out of USCIS. So it's always best to get things done in a timely manner, and then also ensure that you're working with Immigration Counsel to set timeframe expectations so that everybody understands what to expect and what those timeframes are. Obviously, those vary, but it's good to have a general understanding as to how long it does take to adjudicate. On a positive note, when USCIS does allow for premium processing, as it is now, premium processing is available. And what premium processing means is that upon filing the petition with USCIS, once they receive it, 15 days after that filing, and that's calendar days, not business days, USCIS must take action. And what that means is USCIS can approve, issue a request for evidence, or deny the petition. Generally speaking, we don't typically see that flat-out denial. RFEs are more common if USCIS has questions. However, because the O1, given its higher burden when it comes to all the factors you have to prove, not legal burden, but there's a lot of factors that you need to prove to get to that extraordinary ability, it is a good idea to be very thorough up front, have those one-on-one conversations to ensure that you're getting the entire full understanding as to how extraordinary the individual, him or herself, is, because a lot of the times what you'll find is, especially with the individuals that I've worked with, is not only have they excelled in one area, but they have some unique attributes as well. And that's always a good idea to add those tidbits that really identify them as being unique, exceptional individuals that will really contribute to their employers and the United States as well. So, yep, thank you. Next slide. So what it comes down to is as with most petitions, there are some additional, just food for thought items to demonstrate the validity of the job offer and understanding as to the terms as to how the extraordinary individual will be employed by the company and what they're going to be doing and what those expectations are. If there are any specific, very specific plans that you're coming in for, they're coming in to speak or to educate or to, they developed a novel scientific method and you're bringing them over to teach your particular scientist how to implement that at your company, things along those natures, just really understanding the whys and hows of them and why they're being employed. Again, that tells the story. And as I mentioned earlier, some of the, particularly when it comes to sciences, can be very complex. And so having a good understanding as to the practical nature of why these specific individuals, you want to employ them, because certainly at a high level extraordinary position, there have been, as I can imagine from experience, a lot of time and investment made in identifying the candidate, speaking with them, having them interviewed and all the way to the final job offer. There's been a lot of time and cost involved. And so making sure that those characteristics are identified from start to finish as to why an individual has been selected is really good. So that goes back to having those individualized, personalized conversations to ensure that you have all the information regarding why the person has been identified. And I think that goes with conversations with our clients, the petitioning employers, but also with the individuals themselves, because they obviously are the subject matter experts as to why they are extraordinary when it comes down to it. So really looking at this from a high level all the way down into the weeds and ensuring that you have those conversations to identify all of those points, because those points, those factors that I've been talking about, are what is going to lay the foundation for the petition that you're filing with USCIS itself. And, as Eric very kindly mentioned earlier, one of my main goals is to have a Nobel Peace Prize winner. That's, I think, probably the most straightforward one that I would see. But it's the idea that there are ways to demonstrate somebody's extraordinary ability, and they're preset and they're defined by regulation with U.S. Citizenship and Immigration Services as to what you need to prove to demonstrate how or why somebody is extraordinary. So international, national recognition, being acknowledged within your field of endeavor. I think, again, the Nobel Peace Prize is probably that sort of top-notch one that I hope to encounter at some point in my career. And then also another factor from an O1A perspective, so scientists and business people and the like, being a membership that you need to actually qualify for. So being asked to join an association or an affiliation, given your expertise in a particular field, and that you can, being a recipient of such a prize. So it's a situation where the way that you demonstrate that international or national acclaim is, again, by the work that's been done by that individual within those associations or in prizes or awards that they've received. And given different industries, these are going to vary. So again, going back to those conversations that are necessary, just making sure that you have those upfront conversations so that you can really understand the field itself. I'm a lawyer, I'm not a scientist, and I'm not, this is kind of looking at the law perspective, having those conversations will really help in identifying these factors that ultimately prove an individual is extraordinary to the U.S. Citizenship and Immigration Services. And as an aside, before we move on to the next slide, 3 of these factors will need to be met. But the more you have, the more persuasive the petition will be. So it's always a good idea to make sure that you are having those conversations. So in addition to prizes and membership in association, the other factors that can be used to demonstrate that an individual is extraordinary for an ONA perspective, if you want to move to the next slide, Eric, are an individual, their scientific contributions, business-related contributions. I think that one of the interesting factors in this is, you know, there are a lot of online resources that if a client proposes an individual and provides you with their CV or their resume, you know, you can really go in and kind of look at the contributions that are out there in really describing them. One way of demonstrating this is speaking to colleagues and individuals who have benefited from these contributions, business or scientific, and that's where that information really comes into play. I think that having, or another factor again, is having or being in a critical role for an organization. You know, this, I think probably a common description of this would be, you know, a high-level executive at an organization abroad who has led the charge in developing, say, a certain business process or a certain product, and showing here, I like to show what they've done from a qualitative perspective, developing a product and the like, but also it's rough numbers here work too. Looking at an individual who, say, has turned, like in the business community, who's turned a business around and brought profit. There are so many different ways to look at these critical capacity or essential capacity roles that, again, those conversations become critical for you or for me as an attorney, for that matter. And obviously, these individuals who are extraordinary generally do have or command a high salary. That goes back to the original, you know, job offer letter, contracts, et cetera, for bringing an individual over. And that's probably one of the most straightforward factors to consider, because it is simply a dollar sign. But that certainly adds to and is a factor that is important to take of note when you're looking at that, and certainly can help add to the persuasive evidence that you're submitting to USCIS to demonstrate why this person is so extraordinary. And then continuing with the O1A and options for factors that of which 3 need to be demonstrated, authoring articles. So, and that and the novel contributions kind of go hand in hand. Typically when somebody makes a novel contribution, there's typically an article that they've written about it or that somebody else has cited their work, which goes into our next one. There's been coverage on the person based on their extraordinary nature, whether it's articles written in journals or on TV. Just having those, I have definitely submitted back in the day when there were, you know, CDs that you would normally use to access videos on a computer. I would submit those. Now it's more like a flash drive, but just having those there really adds to personalize this particular visa petition. And these are very personal because it is so based on an individual's success and career. And then another item is not only associations that we talked about earlier, but having the foreign national beneficiary of the O1 actively reach out and be judges of people within their own community. Being a judge of somebody within your field of expertise or community, that demonstrates that you've been identified as an expert and your opinion counts. And that's why I think that factor is certainly a unique factor in this overall set of ones that we've discussed, but one that definitely shows acknowledgement through peers. Now moving on to the O1B. This one is a little more different, and this one is looking at the arts, so motion picture and television. So instead of we're looking at Academy Awards or an Emmy or a Grammy or a Directors Guild Award, as mentioned. And again, it comes down to being able to evidence three of these ultimate factors to demonstrate, the more, the stronger you have. And as you can see, a lot of these puzzle pieces can come together, and one factor can potentially prove, or one set of facts from an evidentiary perspective can often prove more than one factor. So again, it's really important to have those conversations. Playing a leading role or starring participant in a production or event with critical reviews and having that overall success in coming into either acting, as an example, doing that and really being endorsed by your community or your guild, for that matter. That is one definite way of definitely demonstrating within the motion picture and television industry you are, for lack of a better term, a star, and therefore extraordinary and able to come into the United States on an O1. It's, again, much like the business and scientists, it's national or international acclaim for the work that you have created, and getting acknowledgement for that from the media and even within, again, your peers, so to speak. Moving on to the next slide here, and I guess comes down to it, extraordinary star capabilities, and being brought in to star in a new movie or star in a new television series, being that one actor in this particular hypothetical of being selected out of the how many actors that have potentially auditioned for a role comes down to it. And that in and of itself, having those statistics, so it's not only getting the role, but how many people, auditioned or the like, and having that raw data really helps to show that person's acclaim and that they were the one to be selected due to their extraordinary ability. And then, the major critical success. So that also comes down to numbers and the like. I've found having practical explanations in more complex matters and demonstrating, as I mentioned earlier, from a business perspective, say that you really are into change management and being able to turn companies around and become very profitable. Again, these are all examples. While having success in the box office, so to speak, is another way of demonstrating that. And so, or ratings or anything along those lines to demonstrate that you have that following. This is a little bit different, obviously, when it comes down to business. You can check ratings, you know who wins the awards, but this one is a numbers and is a really good factor to demonstrate, if possible, if pursuing an O1B. And then, as with, again, very similar to the O1A, it's receiving recognition and having an individual or other experts within the field, whether it be as a director, an actor, or the like, being able to attest to your accomplishments within the field. And then finally, that high salary. Again, it's a pretty straightforward factor, but it's certainly one that is, particularly for the higher level positions, for those individuals who are extraordinary, a good factor to have, because it demonstrates that they are being compensated for their extraordinary abilities. So that's part of the sum. The O1A and O1B, they're not exactly worded the same, but they kind of have the same principle. Is, again, looking at how you can tangibly demonstrate somebody is extraordinary. So they're taking something that seems sort of intangible and turning it into actual documentation to help demonstrate how individuals are extraordinary given their field of expertise. And oftentimes, not all the time, but oftentimes, there is a necessity to actually get an advisory opinion. That's typically when there are, say, unions or guilds involved, and they need to sign off and sort of get that pre-approval before you even submit to the U.S. Citizenship and Immigration Services. If you find yourself in a situation where you know a union or a guild or the like are involved, I would say that it's probably a good idea to reach out to that guild sooner rather than later, because that is one piece of information that is necessary for the petition itself. And so having that be your last step it could delay the filing. So just a little food for thought there. And then upon approval, the U.S. citizenship for that initial O1, the U.S. Citizenship and Immigration Services should issue the O1 for a three-year time frame. An extension should be issued in one-year increments after that. And again, it's just making sure that any updates to the O1's contributions are there, and also the ongoing and necessary services within the United States are needed as well. Now, for those individuals who are in the United States, say in another non-immigrant visa classification, say an H-1B or an L or the like, we can file a change of status because you're in the United States. Then, upon approval and receipt of the O1 approval, that individual can start working in the O1 position. The second option is the DS-160, or applying once USCIS has approved the O1. If an individual is abroad, they're going to apply at a U.S. consulate or embassy to obtain an O1 visa in their passport, and then they're able to enter the United States in O1 status using the O1 approval notice and the O1 visa stamp in their passport. Now, I'm sure that most, if not everybody on this call is aware that U.S. consulates and embassies right now are closed due to COVID-19. Once those U.S. consulates and embassies open back up for immigrant and non-immigrant visa services, O1s are eligible at this point in time to then apply for their O1 visas to enter the United States. And Canadians are visa exempt. For the most part, Canadians are visa exempt. There are certain exceptions to that. But what that ultimately means is if a Canadian is outside the United States and not within the United States, that change of status circumstance that I talked to, point 1 on this slide, they can actually take the O1 approval notice presented at the border, wherever they enter it, being land or by airplane, and just present the approval notice to be admitted in O1 non-immigrant status.
Great. Thank you so much for
that is the process.
Yeah. Thank you so much for leading the second half of that presentation, Sarah. I really appreciate it. And as you mentioned, there's a lot of steps involved. So really glad to hear you kind of explain the entire process. So with that, I'd like to open the floor up to questions for our audience. And we did get a couple coming in. So we are going to take a look to see if we can answer them. Again, we can only answer general questions about the O visa. Really cannot get into any specifics. In those instances, please consult with your immigration attorney. And as we wait for some more questions to roll in, Sarah, I sent you one via Teams. If you want to take a look at that, just to make sure it's okay.
Sure. The question itself is, what would be an example of jobs for O2? So I think in this instance, as I said, it's an integral or an essential part of the role. So you have individuals, say an acting coach as an example for an actor, that potentially is a necessary and critical part of that individual coming into the United States as an essential employee for the O1 to perform in the movie. That could potentially be an option. I don't want to obviously say that everything will be, but that's kind of how I look at it. When you look at somebody's role, anybody who assists in ensuring that they can perform to the best of their abilities, that would be an example that I would use.
Gotcha. And just sending over 2 more questions. And Sarah, before you answer those, I just do want to highlight the 2 upcoming webinars that we have. Next week, restarting your organization's hiring initiatives after COVID-19. And then July 22nd, an introduction to the F1 visa and STEM OPT. There is actually news that came out yesterday regarding the F1. So that will also be discussed in that July 22nd webinar.
Sure thing. So one of the questions that was posed is, when can I start the O1 visa process? Well, that would certainly depend on the circumstances, the job, when it starts. If you know the job is starting as soon as possible, then obviously starting the O1 visa process and reaching out to an attorney now is probably the way to go. However, if the job isn't for another 6 months, you can still start. So I would certainly recommend reaching out to Immigration Counsel so that they can determine when would be the best time to start, because as I said, preparing these petitions, while the process itself is straightforward and like most non-immigrant visa petitions for work authorization, preparing for it is, there's a lot of work to do. So I would say the sooner the better. And the next question is, when can the O1 be a useful tool? I've often seen the O1 as a useful tool for multinational or national companies within the United States when they have an executive who is outside the United States. H-1B cap isn't available, a little more straightforward, less work for everybody visa category for executives. Those types of positions, I've definitely seen the O1 be a very useful tool from a corporate perspective. But again, it really comes down to the candidate, him or herself, and really understanding the what makes that individual unique, what makes that individual extraordinary. And so having an assessment when you have a candidate and you think, wow, this person is, sort of the person we need and nobody else. Again, reach out to Immigration Counsel if immigration or immigration sponsorship is required, because that could potentially be an option for you. Another question is, how does the O1 differ from EB1 extraordinary ability? The O1 is non-immigrant, meaning the work is temporary in nature, initial period of 3 years of work authorized status with extension in 1-year increments. The EB1 extraordinary ability, that is for the permanent residency process. So the factors align, but that would be the first step towards the green card.
Gotcha. Great. Thank you for answering those. And I think that is where we are going to end things. Those are the those are a good batch of questions to answer over the air live. So with that, Sarah, thank you so much for joining us for the presentation today and explaining the O1A, O1B visas. Very, very insightful. And to our attendees, thank you so much for joining us this afternoon. We'll give everyone back about 3 minutes in their day. And as I mentioned at the top of the hour, please keep an eye out for the webinar recording, the slide deck, and continuing education credits that will arrive in your inboxes tomorrow afternoon. So with that, have a good rest of your Tuesday and have a good upcoming week.